5:33 now. In a matter of hours, all eyes on Athens as court convenes for another hearing for the man accused in the killing of 22-year-old nursing student Laken Riley.
This hearing comes one day before jury selection is scheduled to get underway in the trial against suspect Jose Ibarra. 11 Alive's Liza Lucas is following this case for us this morning. Liza, what are we learning?
Well, we know that hearing is set to begin at 10 a.m. this morning in Athens and follows a lot of back and forth lately between the prosecution and the defense over what evidence exactly the jury should be able to hear. Now, as a reminder, a judge ruled on Friday denying 3 motions by the defense to suppress some of the DNA evidence, which included cell phone data, DNA from Riley's fingernails and fingerprints found on her phone. During a previous hearing, both sides made their case, with prosecutors questioning an FBI agent and then defending how that evidence was collected, while Ibarra's team pushed back.
And in searching 1B7 and 1B8, did you stay within the confines of the scopes of those warrants?
Yes.
There is no limitation as to the data the state could have seized based on their interpretation of the warrant they got. And so for that reason, Your Honor, we ask that Your Honor grant our motion to suppress, or at the very least, limit the data that the state can use at trial to the data time range authorized by the warrant.
Again, the defense's motion and that request was denied. The judge ultimately deciding that DNA evidence should indeed be allowed. Now, the defense's request to move the trial out of Athens was also previously denied. Following the hearing today, as you mentioned from the top, we also expect jury selection to begin Wednesday, and then the trial looms with the expectation it will start next week. We'll, of course, keep you updated on the very latest from court as that hearing gets underway.
All right, welcome back Inside the Law, everybody. I'm your host, Philip Holloway. Today is a trial watching day, or a pretrial hearing watching day, of course, in the case involving Jose Ibarra, accused of the on-campus murder of Athens, Georgia student Laken Riley. By way of background, I'm watching a couple of places to make sure I understand where and when this hearing this morning is going to start. What I can tell you is that the subject matter of the hearing is a little bit of I'll say a mystery. Apparently, my sources are telling me this is not the result of something that was filed by either the prosecution or the defense. It's not a surprise guilty plea, I'm told, which would have been my other guess. And so my sources are unable to tell me exactly what this is. I know jury selection is set to start tomorrow, and it's not uncommon for housekeeping matters to be taken up. But I'm also told it's not something that the court necessarily took it upon itself to schedule either. So I'm sure there's a reasonable explanation for it, but nobody seems to know what the subject matter of today's hearing is. One other wrinkle, folks, the last working elevator in the Athens Clark County Courthouse is apparently out of commission. So the judge is having all of his court today, I am told, let's see if I can pull this up. He's having all of it in the municipal court building over in Athens. Other judges are having court in other places as well in Athens and Clark County. And so I don't know what that's done, if anything, to the camera setup. I do know that in Georgia, there's something called a Rule 22 that is required under the rules of court. Media outlets have to get permission from the judge to, take pictures or video. Those Rule 22s have been submitted. They've been granted. All of the media outlets, they share the same camera. It's called a pool camera. So what I don't know yet is whether the elevator issue in the courthouse is something that is disrupting the plans. I am keeping an eye on, as I said, a couple of different live streams that I'm told are going to carry it. So up until about 15 minutes ago, I was a little unsure if we were going to be able to go forward. Now I'm only like 3% unsure that there's going to be a live stream from court. but there's a couple of feeds up, and I'm watching right now, and I'm glad that you guys can join me here inside the law, and we can watch it together. By way of background, you may remember from previous live streams, there was some pretrial motions seeking to keep evidence out of the case, seeking to exclude like DNA and information from cell phones, things that were taken pursuant to search warrants in the case. Jose Ibarra, of course, is the famously illegal migrant from South America who is accused of the killing of nursing student Laken Riley on the campus of the University of Georgia. It's gathered lots of pretrial attention, both in the local media, but also in the national and even the international media, quite frankly. So there was motions to keep the trial out of Athens, Clarke County and move it somewhere else due to pretrial publicity. But look, Athens, Clarke County is one of the areas in Georgia that it's pretty unique. It's if you look at it like in the recent election, for example, Georgia had a lot of red, but these pockets of blue, and one of the pockets of deep blue is Athens, Clarke County. If this case were moved to any other part of the state, to the extent politics plays a role in this case, it might be, not what the defense would necessarily want to do. I appreciate everybody who's joining me here. I'm looking at the live chat. I see we've got folks in from all over the place. I see we've got Texas and lots of other places throughout the United States. And I even wouldn't be surprised if we don't see some international viewers in here with us today as well. Again, I'm keeping an eye on it. I would appreciate looking at your comments. I'll do my best to ask questions. I try not to interrupt, but I will be active, I think, in the chat. And if I need to chime in, I'm going to keep my microphone open. So, I may chime in with any explanations or to answer any questions depending on what's going on. I see we've got London in the UK is here. We've got let's see, there's Washington State. Hello, Washington State. And we got Paige coming from Texas, which is where I went to law school. Hello, Paige. And we've got, looks like Eufaula, Alabama, I guess. We've got Michigan in the house. We've got, of course, Atlanta, Georgia. We've got Columbus, Georgia. We've got folks coming in from everywhere. Oh, and even someone local in Athens. So Athens Retro Girl, maybe you can go down to the municipal court and tell us if in fact they are starting court this morning, because I'm just very curious to see how all of this elevator issue and all of these things are going to come into play here this morning. I'm at some point, I feel like I might just run out of things to say, waiting on court to start. Court was scheduled at 10 o'clock. It's now 10:05. Courts are notoriously, let's just say, untimely in how they get started. And oftentimes, they can schedule things at 9 or 10 o'clock, and it may take, sometimes minutes or hours before things actually get underway. Hopefully that's not the case. I will tell you this. I know that the judge had another published calendar. It was called a plea calendar that was scheduled for 9 o'clock in the morning. It wouldn't surprise me if that calendar is not running behind. I'm checking with my sources to let me know, and give me send a quick text here. Let me know if you hear about any delays. And so we'll just see. We'll see what happens. The judge had another calendar, published calendar scheduled for 9 o'clock in the morning. It's called a plea calendar, but it's basically a status calendar. It doesn't mean every case on that calendar is going to be entering a plea. Jury selection is set to get underway tomorrow. There was a motion for a continuance that was filed on, I think it was Friday, today being Tuesday the 12th. The motion for continuance, I understand, was denied. Also, as we saw in the introductory video, we see that there were a number of motions that were denied by the judge, including the motion to suppress lots of different kinds of evidence in the case. So the judge has indicated that he's ready to get this case going. He wants to get this case tried. They put it off until after the election so that there wouldn't be any, I guess, political, we want cases to be decided based on the law and the facts, and to get rid of any political considerations to the extent that you can. I'm going to just, if you'll bear with me, I'm going to just play this news clip one more time, just so I can get something together. And I'm monitoring the couple of feeds, but by way of refresher, here is the latest news on the case.
5:33 now. In a matter of hours, all eyes on Athens as court convenes for another hearing for the man accused in the killing of 22-year-old nursing student Laken Riley.
This hearing comes one day before jury selection is scheduled to get underway in the trial against suspect Jose Ibarra. 11 Alive's Liza Lucas is following this case for us this morning. Liza, what are we learning?
Well, we know that hearing is set to begin at 10 a.m. this morning in Athens and follows a lot of back and forth lately between the prosecution and the defense over what evidence exactly the jury should be able to hear. Now, as a reminder, a judge ruled on Friday denying 3 motions by the defense to suppress some of the DNA evidence, which included cell phone data, DNA from Riley's fingernails, and fingerprints found on her phone. During a previous hearing, both sides made their case, with prosecutors questioning an FBI agent and then defending how that evidence was collected, while Ibarra's team pushed back.
And in searching 1B7 and 1B8, did you stay within the confines of the scopes of those warrants?
Yes.
There is no limitation as to the data the state could have seized based on their interpretation of the warrant they got. And so for that reason, Your Honor, we ask that Your Honor grant our motion to suppress, or at the very least, limit the data that the state can use at trial to the data time range authorized by the warrant.
Again, the defense's motion and that request was denied. The judge ultimately deciding that DNA evidence should indeed be allowed. Now, the defense's request to move the trial out of Athens was also previously denied. Following the hearing today, as you mentioned from the top, we also expect jury selection to begin Wednesday, and then the trial looms with the expectation it will start next week. We'll, of course, keep you updated on the very latest from court as that hearing gets underway. In Atlanta, Liza Lucas, 11 Alive News.
Liza, thank you. We know there's a lot of interest in this trial, so we will stream it for you on 11 Alive Plus this morning. You can download the app to any streaming device for free.
All right. So there you have the latest news. I'm going to go ahead and I've started starring. I've seen a few questions, and I'll get to those. But before we do that, I want to mention that the current district attorney in Athens, Clarke County was defeated this past week in the election. He came under a lot of fire because, she's apparently never won a murder trial over there, and her office wins very few felony jury trials. It's my understanding as well. She has a very different outlook on criminal prosecutions in general, and her philosophy, let's just say, did not jive with the majority of the Athens Clarke County voters, and so she has been ousted from office, or at least she will be at the end of the year. The new DA will take office on January 1st. Somebody was asking me, is that going to affect this case? And the answer is no, and let me explain why. DA Gonzalez has taken the position that she was going to bring in, from the very beginning, she decided to bring in Um, she decided to bring in a lawyer from the Prosecuting Attorneys Council of Georgia. The PAC in Georgia is the state agency that is designed to assist local prosecutors in various ways. And one way they can do that is they can add or supplement with special trial assistance when it's needed. So they brought in a lawyer who knows how to try cases, who's an outside lawyer, doesn't work directly for the DA, but is serving as the prosecuting attorney in this case. So Gonzalez, though, however, being the DA, is ultimately responsible for criminal prosecutions in the county, and she has determined that this case would not be a death penalty case, although in Georgia it would have qualified for the death penalty. Athens Retro Girl says DA Gonzalez just got voted out, but had appointed a special prosecutor. Gonzalez was a Soros-backed entertainment lawyer who had never tried a case in her career. So look, this is people have said, why can't you got Athens is a very blue county. Why couldn't Fonnie Willis be voted out in Fulton County as well? Willis just did not have she just didn't have an opponent who's a Democrat, right? If there was Courtney Kramer, who's a Republican, but Republicans don't do well generally in Fulton County. I think Courtney got over 30% of the vote, though, where President-elect Trump only got 27%. So she outperformed the president-elect in Fulton County. Athens is a very different breed of cat, so to speak, or breed of dog, maybe I should say. Shout out to the University of Georgia. But looks like we've got some movement. Let's see what's going on here in the courtroom.
Also have agreed that they have discussed this with their client, they agreed with this waiver, and so they're inquired from both the defendant and defense counsel about the voluntariness, the freeliness, for lack of a better term, and the knowing waiver of the right to a trial by jury.
Your Honor, I do have a waiver for you to consider. May I approach?
Yes.
We stand ready to answer the questions Your Honor has.
Thank you. Let me read it.
Yes, sir.
I hope he speaks into the microphone because the audio in the courtroom is not the best. It looks like I think the defendant might be waiving his right to a jury trial. This is really, really interesting. Very strange.
I reviewed the waiver, initialed and signed by the defendant, and Mr. Kirby, in this case, is lawyer for this particular matter. Mr. Ibarra, I need to ask you, did you go over the waiver of jury trial and agreement to proceed with it?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
Did you go over that with your attorney?
Yes, Your Honor.
Was it freely, knowingly, and intelligently signed and considered?
Yes, Your Honor.
Do you have any questions about your decision to waive a jury trial in this case?
No questions.
Have you had enough time to talk to your lawyers about that?
Yes, Your Honor.
Do you understand that if I grant this request, it cannot be revoked by you going forward?
Yes, Your Honor. Yes, Your Honor. Yes, Your Honor.
Mr. Kirby, let me ask you on the record, have you had sufficient time to go over this waiver with your client?
I have, Judge.
And can you say collectively, you and the other defense counsel, are you all in agreement with your client's decision to make this election?
We are, Judge.
Is there anything else you think I need to know on this subject?
Not about this matter, Judge.
Ms. Ross, anything?
May I inquire, I know it may seem quite silly because the defendant is incarcerated, but stranger things have happened. Would the court please inquire to make sure that the defendant's age and the fact that he's not under the influence of any drugs and or alcohol at the time today or at the time that he made that decision? And I'd also like to inquire, I understand that Mr. Kirby does speak Spanish. And I know that they went over the form and have discussed this with their client, and just want to make sure that he either did it in Spanish or with an interpreter or both when he discussed this matter with his client.
Mr. Ibarra, are you under the influence of any sort of drugs or alcohol today?
Is he under the influence of anything? That's a great question because you've got to be to waive your right to a jury.
The influence of drugs or alcohol when you considered the waiver of the terms included in this form?
No, Your Honor.
Mr. Kirby, could you describe how did you translate with the assistance of Ms. Smith, or how did you discuss this with Mr. Ibarra?
Judge, what I can tell you is that the form was translated and we reviewed it with Ms. Smith, who is an interpreter for the court.
And then, were you present when that took place?
I was.
Is it your belief or understanding that she translated it to your client in an appropriate way?
I don't have any reason to think that that was not done, Judge.
And I ask you because I understand you speak Spanish.
I understand, Judge. Without getting into my fluency of Spanish, we brought Ms. Smith in for a reason. I am not qualified to tell you exactly what those words were. It was reviewed just like in any other case with a certified court reporter and court interpreter. And we have stated that Mr. Ibarra has stated that he understood it. We have stated that we've gone over it with him, and I'll leave it at that.
What else, Ms. Ross?
That's it, Your Honor. May the parties have an opportunity to discuss scheduling with the court, and that can actually be in chambers if it pleases the court.
Yes.
Thank you.
We can discuss that. I also recognize that Mr. Kirby has filed a follow-up motion for continuance on the true or legal issue. Is that true?
That's correct, Judge. I think that it would be very similar to what we argued at the motion, but given the court's order on that, I have a feeling I know what the court is going to do. We just want to renew that motion.
Well, and I understand your obligation to do that. I can appreciate that. I think it's appropriate that if we probably need to address that now on the record. Have you had a chance to see that? I just saw it this morning.
I did see it, Your Honor. In the state's position on it, I think we have a little factual disagreement about the timing of matters. I'll repeat my position on the motion to continue, or at least putting all of the dates in context for the court. In the terms of the true allele DNA results in this case. So the very first true allele report in this case was issued in April of 2024. That report was not disclosed to the defense until the very first round of discovery, which came out in May of 2024. So as of May of 2024, everybody is on alert that that some of the results, not all of the results, because some of the results are traditional DNA, some of the results are YSTR DNA, but there are also true allele results in this case. And so in May, everybody was aware that we have true allele results in this case. The true allele testing continued because this case is not yet 9 months old, so things were continuously tested. As things are tested and as reports became available, they were disclosed to the defense. The very last true allele report in this case was issued in September of 2024. It wasn't until the last results were issued in this case that the GBI could disclose and give to everyone, the state, meaning the prosecutors and the defense, the raw data that was produced as a result of the true allele testing in this case. And that raw data was timely subpoenaed by the defense. The prosecution in this case, in order to assist the defense, in order to get it quicker, also filed an open records request because we're permitted to do that in an open case. We worked together, defense and prosecution, as quickly as possible to make sure that they got the raw data as soon as they could. The raw data was produced to them in October, I think it was October 11th of 2024 is when they obtained the raw data from the true allele results in this case. And so I put all of those dates to the court in context for the court to consider this ruling. But it was known in May of this year that we have true allele, and the true allele was part of the DNA testing done in this case. And I will leave the court with that knowledge and those timelines and defer to the court.
Yes.
And Judge, I appreciate the state's position, I guess, that we would have known that this was a true allele case. But in speaking to the experts and speaking to the attorneys that are more knowledgeable than I am about this subject, the reports that are turned over to the defense, the one-page reports that give the results of those tests are not what experts can analyze. And so I agree with Ms. Ross, and they were very helpful in trying to get that information to us. But the actual time that we have had the data that can be analyzed and evaluated by an expert is insufficient for us to hire that expert or to have them looked over.
I will deny the request for continuance based on what I've already stated in the previous order, but I understand your need to request it. But I will deny that. Let me state for the record that I do find Mr. Ibarra's waiver for jury trial is made voluntarily based on testimony here today, as well as the statement that he has that's been provided, apparently he signed today in the presence of his attorney.
He's finding that the waiver was freely and voluntarily made. Audio is terrible.
You all, I'm willing, if I think we do have the option to go into chambers and discuss scheduling matters. That would be all it would be to try to figure that out. If there's something else, let's talk about it down here. Obviously, I'll give you a chance if you want to speak with your client to make sure he understands and there's no objection about us recessing the matter in open court and resuming upstairs and try to deal with timing of this.
Yes, Your Honor. That works for us.
make sure that that has been interpreted to the defendant so that he knows and he's okay with us going in the chambers to talk scheduling.
That's what I just relayed to Ms. Smith.
Okay, all right. I recognize that there are people here that need to know about the timing, but I want to be able to have this discussion in a meaningful way. I will tell you, you're welcome to stay, and I'll have a report back down here as to anything that's relevant, which is the most relevant thing is going to have that in mind. So, I'll be glad to make that statement. Also, let me say, I recognize, I said this when I first started this morning, as you can tell, we're experiencing some significant physical issues dealing with this plant, this facility. That happened. This is the best court setting that we have available in the courthouse today. Hopefully that will improve, but that's just sort of a day-by-day thing. I agree. I don't all of that started happening this weekend too. So certainly I know that it impacts all of you and how you come and go and what you plan on. And that's the other thing that we'll talk about upstairs is where I think we'll be and how we can do that and that sort of thing.
Yes, sir.
All right. We'll stay upstairs in 10 minutes.
Yes, sir.
Give y'all a chance to get.
Everybody remain seated in the courtroom at the time, please.
All right. Let me just cut this sound off so that I can hear myself, and then we'll get into some of the questions that I know you guys have. So this is very surprising to me. This is the rare time a defendant in a capital case, and I say capital because death penalty is not on the table. The district attorney has ruled that out long ago in this case. But the defendant has apparently waived his right to a trial by jury. Now, I'm keeping an eye on the courtroom. The audio was terrible. It sounds like they were going to be going back into chambers with the judge at some point to discuss scheduling now that a jury is no longer going to be the jury selection won't be taking place tomorrow as scheduled, apparently. So they're going to discuss scheduling and what that means. I fully suspect Judge Haggard's going to be getting this case tried very quickly. It wouldn't surprise me if he doesn't say, all right, well, if there's no jury selection, then be here Monday morning for opening statements in your bench trial. So I don't understand why the defense would do this. There is no advantage to it. He's not seeking the death penalty. It's life without parole is what he's facing. Just in any given case, when you take the jury out of the equation, the prosecutor has an extreme advantage because instead of having to prove their guilt beyond a reasonable doubt to 12 people who are citizens from the community, who may or usually don't have any like legal training. So the prosecutor now only has to prove his guilt to one man, in this case, a seasoned judge and lawyer who I'm told also had a family member a long time ago was murdered. So it's a bizarre move. I don't understand it. I don't see how there's any advantage to it. Judges, of course, know all about what reasonable doubt is. They see these things in the courtroom all the time. He's denied every motion that the defense filed. Why would you take from a strategic perspective? I don't understand why you would take the jury out of it. All you need, if you're the defense, it may be a long shot, but hey, You take what shots you get. And if all you have is a long shot, then you try to make your long shot, right? And that might be having one juror who is hung. Maybe one juror has some kind of sympathy for the defendant and you get a hung jury. Okay. So you've now eliminated that possibility. The decisions made by the defense, let me back up what you just saw. So in order to waive your right to a jury trial in Georgia, you've got to go on the record like they did here. And the defendant has to say to the court, look, I know that I have the right to a jury trial. I freely and voluntarily have waived that right. Nobody's promised me anything. Nobody's threatened me. This is my free choice. And so you saw this, we call it a colloquy, a discussion back and forth between the judge and the defendant through the interpreter, but also to the defendant's attorneys. In the event of a conviction, this is going to be an issue for appeal. And I think a conviction at this point is a foregone conclusion, but this is going to be part of the appeal, right? Why did the defense attorneys, why did they do this? Were they on board with it? So there's going to be eventually a motion for new trial. I'm getting way ahead of myself. I'm talking about the appeal that I foresee in the future. The one of the issues is going to be ineffective assistance of counsel. Was the law, in other words, you have a right to a lawyer under the Sixth Amendment to the Constitution. So that means you, by extension, you have a right to a lawyer who is effective, to a lawyer who has done a reasonably good job in defending you. Okay. So every decision that the defense makes, and I'm not saying that they are ineffective for this. I'm not saying that this was a mistake, but every decision that the defense lawyers make is scrutinized for potential error on appeal. So what will happen is there will be a motion for a new trial and it will allege ineffective assistance of counsel, among other things. And these lawyers will have to take the stand at that point, and they will have to discuss whether or not this was a matter of strategy of some kind. And if so, what was the basis for that? Attorney-client privilege is waived. It no longer exists at that point. So lawyers can get into the reasons why they made certain decisions. But every issue is going to be up on appeal. So the only thing I can think of is that the defense is essentially saying, you know what? We know we're going to lose the trial. We're going to put all of our eggs in the appeal basket. Okay. We're going to try to say the judge made certain mistakes in his pretrial rulings. They're going to say that the judge should have suppressed evidence, should have suppressed the DNA evidence and things of that nature. But in any event, this is going to be a much shorter trial because we're not going to have a jury in the room. All right. So there was a couple of questions. And I want to look, if you have a question, put it in the chat. I'll do my best to try to catch it. But I think I've already addressed this, but it's worth pointing out Georgia does have the death penalty, and it is used, but it's not being used in this case. The elected district attorney, who is on her way out of office at the end of the year because she lost the election, she decided this would not be a death penalty case, although I do think it would have qualified. Which, of course, is the next question. Brenda asks, why is he not getting the death penalty? The short answer is that the district attorney made the decision not to seek the death penalty, even though a special prosecutor from the prosecuting attorney's council is the trial lawyer. Her name is Sheila Ross, by the way. She's from the prosecuting attorney's council. She's very capable. The local DA has not ever won any murder trials, and I think maybe not even any felony jury trials. And she didn't have any trial experience. She was an entertainment lawyer before she became DA. So she's on the way out, but she made the decision not to seek the death penalty. So there you have it. I think that there might be some other stuff that's going to take place, perhaps on the record, but I'm not sure. I don't think there's going to be much, if anything. I know they were going to talk about scheduling in chambers. I'm keeping an eye on the courtroom. The stream is still up. But there's apparently the judge is off the bench. So we'll take a few minutes to see what's gonna happen there. Athens Retro Girl apparently is in the know and says you can research the murder trial of the judge's father from 1992. Interesting. Now, look, I for one, I don't. This judge has an outstanding reputation. I am sure this is not the first murder case that he's handled as a judge, but what I do think is that. Well, I don't know what I think. This is all very bizarre. I just can't. I'm sure it's happened. I just can't think of a recent example of when a murder defendant waived a jury trial. I've heard of it where they would waive the jury trial in exchange for taking the death penalty off the table, but this was not part of any such of a deal. This is Jamie Hood was another case, very famous case in Athens, and the judge presided over that case. You should research that. It's a very interesting case. I think some of it's even back in the news recently, as far as the appeals. But the judge did a by all accounts a very good job, and he does have a stellar reputation. Speaking of his reputation, he has a reputation of being a very strict sentencing judge. Now, speaking of a sentence in Georgia, the only thing that you can get, like if you're convicted of murder, there's only essentially three choices. It's life in prison with parole, life in prison without parole, or death penalty. Okay. So death penalty is off the table. There's just no way that in the event of a conviction, you're not looking at a life without parole. I've had people asking me, and please feel free to, by the way, if you have a question, if you start out by saying question in the chat, it helps me identify it as a question versus a comment, and I might be more likely to see it and flag it so that I can address it here live with you guys. But I think life without parole is going to happen. People have asked me, well, is he going to be deported because he's an illegal migrant from Guatemala or Venezuela? It escapes me at the moment, but South America, as is some of his family members, including, I think, a brother or two. The answer to that is no. If he gets life, particularly life without parole, and he spends the rest of his life in a Georgia prison, he would never be deported. In the unlikely event that he gets out of the Georgia prison, then yes, he would be subject to deportation. But when individuals who are here illegally, like he is, if they have criminal cases and they are convicted and they have to do their jail sentence before the immigration officials can do anything with them. So, and that makes logical sense, I think. So, I suspect he's going to be spending the rest of his days in a Georgia prison. Still checking in. I don't see any movement or action in the court. The judge said 10 minutes, and it's been about that long. So we'll keep an eye on it, see if they come back for anything. All right. Yeah, that's right. MDR says Venezuela. That's correct. All right. MDR asked the question, why go to a bench trial instead of just admitting guilt, knowing the odds of a judge finding him guilty? So that's an excellent question. Thank you for that. This is something I meant to point out a little while ago. We would call this, in the legal community, we call this a slow plea of guilty, because that's essentially what's going to happen. It's a foregone conclusion that he's going to be found guilty. And so the reason that you have the bench trial, though, is because you have all of these issues that you still get to appeal. If you plead guilty, then all of the judge's rulings that he's made on all of the denials of the motions to suppress, all of those issues go away and there is no appeal if you plead guilty. If you go through a bench trial and the judge finds you guilty, then all of the pretrial rulings and all of the in-trial rulings that might be objectionable to the defense, those are all potential issues for an appeal. So they are waiving their right to a jury trial, but they are apparently putting all of their eggs, like I said, into the appeal basket. Still nothing going on in the courtroom yet. They said 10 minutes. We'll keep checking on that. I don't know what else they might have to discuss unless it's possibly a continuance. The scheduling they said was going to be done in chambers. So I don't know. We don't know. All right. Go ahead and put any questions that you've got for me in the chat, and I'll keep checking on it. I'm also checking on some sources I'm checking in with over in Athens. Misty asked, do I think the defense is doing this to get around this judge? No. I mean, in fact, it's just the opposite, Misty. The judge is going to be not only the judge, he's going to be the jury. He's now going to be what's called the trier of fact. Normally, when you have a jury, the jury is the trier of fact. But in this case, the judge is going to be doing the jury's job and deciding whether the state has proved their case beyond a reasonable doubt, just like a jury would have done. So, and then, well, of course, when he finds Ibarra guilty, he's going to sentence him to life without parole. I think the judge is interested in getting this case done. He wants to get it done this year. I think it's going to be over. At this point, it may be over by Thanksgiving. I just don't know. Okay, look, when you don't have a jury, you don't have to send the jury in and out. You don't have to worry about charge conferences and reading long jury instructions. You just take out so much of the trial. It's just going to move so much more quickly. Instead of it taking maybe a month, it takes only maybe a few weeks, depending on how many witnesses they take. Misty, yeah, I mean, look, this does get the case to appeal faster. But the reason I don't understand it, Misty, is because the defendant would be able to perhaps, throw the legal equivalent of a Hail Mary pass, hoping that one juror might hold out for an acquittal, and you might get a hung jury. So I don't see any advantage whatsoever to the defense by doing this. So it's quite a perplexing decision to me. Do we think the defense knew Athens Clarke County residents were potentially very upset about the case, regardless of political? Well, I think that's fair. I do think they would have had to know that. They're not going to find any potential juror anywhere else in the state that is maybe less upset. Anytime you pick a jury, the goal is to find, you're not going to find a jury that knows nothing, or a juror. Most likely you're going to find people that have heard of the case, and what you're looking for is a juror that can be fair and impartial under a totality of the circumstances. But look, even if the 12 people that sit on the jury, are upset, they presumably all would have said that they can be fair and impartial. I still, regardless of how upset they might be, if you're the defense, you've got to try to hope for maybe one juror who could maybe hang it up for you. Mary Beth asks, if the verdict is appealed and the new DA is in office, could the death penalty then be reinstated? The answer is no. That's something that has to happen pre-trial. There's a whole different set of legal proceedings and processes in place for death penalty cases. So the death penalty is off the table unless for some reason this trial doesn't go forward. Theoretically, a new DA could take over and dismiss this indictment, get a new indictment, and start all over again, maybe seeking the death penalty. That theoretically, I guess, could happen, but doesn't look like it is going to happen. And hey, look, it just hit me. Maybe that's why they want to go ahead and get this case tried. Maybe they want to make sure the new DA doesn't come in and do a superseding indictment and seek the death penalty. I think that's a little bit far-fetched, but we'll just have to see how it goes. Still keeping an eye on the courtroom here. Let me see if I can get back to it. Still keeping an eye on the courtroom to see what's going on, but so far, nothing. You can see that the feed keeps popping in and out. I mentioned this earlier in case in case you didn't catch it at the beginning. The last working elevator, I'm told, in the Athens Clarke County Courthouse apparently died this weekend, and there's no way to access this judge's courtroom, and it's got to be open to the public, and that means there needs to be proper handicap access. And so without the elevator, they've moved today's proceedings into the city court building instead of the Superior Court courtroom. So the judge is borrowing the city or the municipal court courtroom for today's proceedings. We just need to I'm sorry, folks, I'm keeping an eye on 2 or 3 different things to see what's going on. All right. Go ahead and hit me with your questions, whatever you got. Please put them in the chat. And I'm going to continue to try to monitor court. Let me see if I can hear any sound. Yeah, it's still, there's still nothing going on as far as anybody speaking. So, all right. Yeah, I guess while we got time, if I can answer your questions about anything unrelated, I'm happy to try to do so. Thank you for the comment, Misty. Look, a lot of us had no idea this was going on. This was something that was kind of a surprise that popped up over the weekend, and nobody really knew, at least the public didn't know what it was about. I had some sources tell me, look, you're going to want to watch. I can't tell you what this is about, but you are going to want to watch. And so this was the big surprise. Look, I don't know why it needed to be kept a secret, but a waiver of a jury trial is something that is extremely unusual. I guess maybe they want to keep their options open until the very end in case the defendant changes her mind. Folks are asking me in the chat about other things that are going on, and look, I do want to find out what's going on with the Mershon ruling. I've talked extensively on this channel as recently as this weekend on Sunday about the cases against President-elect Trump. I am very interested to see what's going on, but I'm just not able to multitask. I've got text messages blowing up, all kinds of folks, but I'm doing my best to try to focus on what's going on this hearing and see what all happens. Athens, the question is Athens a sanctuary city? Yeah, it basically is. And it has been, and it's it's come under fire. I think there's going to be a move in the legislature to crack down on that. And I think that Athens' days as a so-called sanctuary city might be numbered. But yes, that was one of the big reasons that this case got into the news. Municipal court is on the first floor of the same courthouse building, Superior Court. Judge Haggard is located on the fourth floor of the same building. So just using the only courtroom on the first floor, so they don't need an elevator. Yeah, I mean, you got to have the courtrooms have to be open to the public, and that includes anybody that needs handicap access. So this makes sense. All right. The new DA ran as an independent, had to collect signatures to get on the. Now, I did not know that. So so the DA lost with a the DA lost on a write-in ballot. That's crazy. I did not know that, but thank you for that information. See, I love it when I learn things from you all. This is your LawTube channel, where we go inside the real justice system and try to show you how things really work in the real world. And sometimes, so we try to learn things, but I love to learn things from you all who are the audience for this channel, and so I appreciate that very, very much. Yep, that's the new DA. Is I'm going to mispronounce this name, Kalki Yalamanchi. Yep. We just say Kalki, okay, or Kalki. But that's right. That is the new DA. And so the new DA, as I said, could theoretically maybe dismiss this case, not this case, but dismiss this indictment, replace it with a superseding indictment, and maybe seek the death penalty. Maybe that's what's going on. That's the only thing so far that I can think of that would make this make any sense to me. While we have a moment, I want to take a minute to thank all of the subscribers. I've got last check, it was 50,400 and some change, and growing. My next getting over 50,000 is a huge honor. Thank you to all of you who have subscribed. Look, if you know anybody who is interested in this kind of content, we do, in addition to covering court proceedings when able, we go in depth behind these court hearings and try to break them down and learn from cases that are in the news every day. So if you know anyone that would be interested in this kind of content, likes this kind of thing, please encourage them to subscribe. If you're watching now and you haven't subscribed, I'd like you to consider please doing that. My next goal is to get to 60,000. I want to go from 50 to 60,000, and from there we'll try to keep growing the channel, because that's what allows me to continue to bring content to the subscribers of this channel. This is not my full-time job. I do this when I can. I still practice law, of course, full-time, and I would love to do more streaming, but I've got to work my day job. So the more subscribers we have, the more it makes sense for me to do more streaming and less of my day job. So please consider subscribing. MDR, tell your mom I said hi, and thank you for your subscription as your mom as well. That's great. Tell your mail carrier, tell your neighbors, tell your best friend, tell your worst enemy, tell everybody you know to subscribe if they are interested in this kind of content. So look, this is some. All right, I think I need to find out who Athens Retro Girl is, because I might need to have her in as a guest here inside the law. So because it's particularly as it pertains to this case. because she apparently is in the know. He won, the new DA won Oconee County, which is, so there's two counties, there's Oconee County and Athens Clarke County in this judicial circuit. He won Oconee County with 76.51% of the votes, and he won a majority in Clarke County with 51.9%. Now, for those of you who don't know, so Athens Clarke County is, it's perfectly blue. It's like the deepest blue color you can think of. And on the other hand, next door, just to the east in Oconee County, is as bright red as you possibly could get. And so you've got this judicial circuit that's composed of one really bright red and one dark blue, and a write-in candidate won both of those counties. That should tell you how unpopular this DA is. By the way, she, just like DA Willis in Fulton County, had challenged and fought off open records request and made the same argument that Willis made on an open records lawsuit, basically saying that the DAs are not subject to being sued under the Open Records Act. Recently, the Georgia Supreme Court said, no, that's wrong. So DA Gonzalez made some case law in Georgia, and it did not favor her position. The Supreme Court of Georgia ruled against her in striking fashion that DAs are not above the law and they are subject to the open records request. So I guess we have her to thank for that, because she made some good law for those of you who are in favor of open courts and open government. I don't think I'm going to be taking over Joe Rogan's spot anytime soon, but I appreciate the sentiment. 14,000 signatures when only 5,000 was required. Yeah, I agree. It does sound like a mandate. All right. We still have nothing going on inside the courtroom. The judge said 10 minutes. I'm going to give it a few more minutes here to see if they come back. Hopefully they will come back soon. Hopefully they will come back soon. All right. Hit me with your questions. What else do you want to know about what we've seen here today? Again, this is very unusual. This is almost unheard of in Georgia for a murder defendant to waive their right to a jury. It just doesn't make a whole lot of sense to me. Doesn't make any sense at all, unless they had maybe they got wind that the new DA was thinking about trying to do a superseding indictment. That's just a theory. I could totally be wrong. But anyway, yeah, so 10 minutes probably does it. Look, everything in the law is understated. If you ask a lawyer how long something is going to take, and they say it's going to take 10 minutes, you can at least double or triple it. That's just kind of how courts work. That's the real, when judges ask for, okay, I want a time announcement from the parties, from this side and that side. How long do y'all think your motion hearing or whatever is going to take? Each side gives an estimate. Well, judge, from the state, it's going to take 30 minutes. The defense will say, okay, it's going to take us an hour. That's an hour and a half. You can at least double that, because if things just always go sideways. Yeah, so I think the judge might be in there scratching his head too. Maybe that's the delay. That's pretty funny. Yeah, so Brock asked a good question. How does this decision even happen? The client does have the final say, but is this a lawyer decision? No, I mean the lawyer has a role. The lawyers can advise the client. They can say, look, this is a terrible idea, or maybe they say this is a great idea. I don't know what they say, but at the end of the day, it is the defendant's decision. But your question makes me think of a little bit deeper into this, because do we think that Jose Ibarra came up with this idea on his own? I think it's unlikely. I don't think that I don't think a person who is not even, who's from another country, has not been here relatively all that long, certainly doesn't know our legal system. How would he know that he has the option to even waive a jury trial? So someone had to give him that idea. I don't know if it was his lawyers. Maybe it was. Maybe it was somebody else. Let's see what's going on here inside the courtroom. Yes, Jenny, they are open to the public.
She's in juvenile court. Does she know we're waiting on her?
No, she said if we need to get her.
Well, then, did you get her? Okay, thank you.
And our victim's family is coming down as well. They're on the stairs. Our victim's family is also coming.
Okay, that's fine. Don't know what it is. Okay, thank you.
None of these, this is a special prosecution team. These don't work for the DA, so they're not going anywhere. Different camera, different sound, or perhaps no sound, as it were. This judge is known for not wearing a robe.
9 a.m. this Friday morning. As previously stated, it's going to be a bench trial. I expect it will be held unless there's some change. I'll let you all know if there's a change. It will be held in my normal courtroom, which is on Thursday. And we'll go off that Friday and pick back up Monday and then into next week as needed. I've got some things I want to take up with the media, but is there anything else that you all have on your mind about that?
No, Your Honor. Just for planning purposes on Friday, are we going to go to 5 p.m. or 6 p.m.?
5, but I will look for a natural break. I mean, if it's, I'll try not to stop in the middle of anybody's testimony. I'll try to finish up, but I'm looking for a full day.
Yes. Oh, yes, sir. I just didn't know if you wanted a full
I'll
day
probably
plus.
go to 6 on Friday. Friday is also, there'll be other things going on in this town, and so people will be looking to get out of town and find a place to stay. Anyway, so.
Till 5. Thank you, sir.
Fine. Anything else we can do?
Not for us, Your Honor.
Okay, and y'all are welcome to stay where you are. I'm going to ask if you will invite the media that is out there in the hallway to come in, please. So some things have been brought to my attention that I think you all need to hear, that we're not going to have anymore. That is trying to talk with the defendant, trying to talk with the lawyers, trying to talk with the family, and certainly any witnesses that come around. I don't want any attempts at conversation with any of them in this courthouse. I can't control outside this courthouse, but I understand this happened today, and I don't know who it was. I didn't ask that. I will tell you, this is the first time I've had to make this sort of admonishment in the few times that I have dealt with this. Not just in this case, it's been pretty reasonable. It may be a function of the close quarters we have, but don't misinterpret that. It's still important for me to maintain the integrity of this process. So I'm asking and expecting you all to abide by that. Are there any questions? Okay. Thank you all. Court's adjourned.
Everybody just remain appropriate just for a second, please.
All right. Well, there you have it. Court is adjourned in the surprise move by Jose Ibarra to waive his right to a jury trial. I got some background information that I'll share with you before we wrap it up. Let's see here. So Judge Haggard, by the way of background, was a family lawyer for many years before he took the bench, and he was a judge in Winterville Municipal Court prior. The two public defenders, Dustin Kirby and Dustin Kirby is one of the public defenders. The defense team surely knows, all about the history with Judge Haggard's father. But look, the fact that they waived this anyway, this I think all speaks to the strength of the state's case. What will happen eventually when the case is appealed, they will testify. The lawyers who represented Ibarra will testify because there's going to be a motion for new trial. The defense team on appeal will investigate whether the lawyers were effective or ineffective as required by the Constitution. So because of that, attorney-client privilege gets waived, and they will explain at some point in the future why this decision was made. Look, these are good lawyers. I'm not saying that they did anything wrong. I'm sure they've got their reasons. We just don't know right now what those reasons are. Okay. So let's just stick a pin in that, and we'll come back to it a few years down the road, and we'll figure out what it all is. There is a good reason. We just don't know what it is. I'm told that, Judge, you were asking about Judge Haggard and his robe. He doesn't wear one, but apparently none of the judges in Athens wear robes. All right, there you have it. So we're going to keep up with this trial here inside the law, and I want you guys to, like I said, if you haven't subscribed, please subscribe. Ask your friends and your family and your loved ones and your hated ones and anybody else that you can think of. When you go to lunch today, tell them to subscribe here inside the law so we can get to 60,000. All right, that's the goal. Can we get there by the end of the year? Maybe so. I hope so. But thanks to all of you who have decided to join me here today inside the law, and keep an eye here until because we're gonna be covering this case, and we're gonna be covering anything else that happens. We'll be getting into the Trump legal cases as we have news on that. And just remember, folks, if you remember nothing else from this channel, just remember, don't be this guy right here.
Man, can I get a water or something? I'm so high right now, y'all. I'm about to go to sleep on y'all now. I ain't gonna tell you no lie.
Yes, you may. You're gonna take a break soon. Hang in there.
Best moment ever from the Fannie Willis versus Young Thug YSL trial. See you next time here inside the law.